Today's webinar. We are pleased to have Steve Jones with Holland & Hart here to talk to us about some of the changes that are coming to the Clean Water Act. Just want to go over some of the ground rules for the webinar real quick. Everyone's lines will be muted. If you have questions, please type those into the question or chat box, and we will relay those questions to Steve once he finishes his presentation. A copy of the slides and a recording will be sent out to everyone either later today or tomorrow. And with that, I'm going to introduce Steve Jones with Holland & Hart. He has more than 20 years of experience working with both companies and government agencies on energy, environmental, and natural resource matters. He assists public and private companies, including manufacturers, municipalities, oil and gas, mining, and solid waste companies with environmental compliance and permitting, the investigation and remediation of contaminated property, cost recovery, and insurance coverage for environmental issues. Mr. Jones has worked on project and infrastructure permitting under the NEPA, the Clean Water Act, and federal and state statutes, as well as defense of those permits before administrative bodies and in the state and federal courts. Mr. Jones also has particular skill dealing with the investigation, defense, and mitigation of pipeline releases, including responding to enforcement orders issued by regulatory agencies, including the EPA, Utah DEQ, and the Pipeline Hazardous Materials Safety Administration. Mr. Jones has presented at the American Bar Association's annual conference on environmental law in 2009, where his paper was named the best of the conference. He is the former editor of the American Bar Association's Superfund and NRD Litigation Committee newsletter, and the immediate past chair of the executive board of the Washington State Bar Environmental Land Use Section. Prior to joining Holland & Hart, Mr. Jones was a partner at Martin Law in Seattle, Washington. Thank you very much, Steve, for being with us today, and I turn it over to you.
Thank you, Chris. It's my pleasure to be here. For those of you who are watching, let me just say out the gate that I'm very happy to have you send questions via the chat feature as we go through the presentation. And if you want to do that while I'm speaking, I'll try to address those while I'm going on. There's nothing here that is so tightly wound that we can't interrupt or address things if you have questions as they come up. I think we will reserve a period of time at the end for questions. So if you want to hold those until the end of the presentation, that's perfectly all right as well. I'm sure that those of you who are on the webinar are on the webinar because you're interested, either because it's a passing interest or because you've got clients or work for organizations that this is a development that you need to pay attention to. And as I'll discuss in more detail as we go into the presentation, this is a development that everybody needs to pay attention to. The new rule that was just issued significantly broadens the jurisdiction of both EPA and the Corps of Engineers under the Clean Water Act. As I'll talk about in just a little bit, it has a fairly detailed history in terms of how the rule that was just adopted was generated. Largely, the history involves litigation and case law that was expressed by the United States Supreme Court, but the jurisdiction under the CWA has implications that actually even go beyond the CWA. So let me get going on that. The rule that we're talking about was first announced on March 25th, and it's a proposed rule defining waters of the United States under the Clean Water Act. It was published in the Federal Register on April 21st, 2014, and has the site, if you need to look it up, of 33 CFR Part 328. It's volume 79 of the Federal Register, number 76. And the Federal Register notice, which I'm holding in my hand, is, I'd say, probably 100 to 200 pages long. And the specific site in volume 79, if you want to look at it after the webinar, is 79 CFR 22188. And again, the date is April 21st, 2014. The reason that that date matters is the publication in the Federal Register is what starts the comment period. And because of the breadth of this new rule, comments are going to be very significant. So if you've got clients or if you work for an entity that will be affected by this rule, the opportunity that you have to comment has already started, and it will extend until the middle of the summer. As with rules of this magnitude, it's not unprecedented for a comment period to be extended, but you shouldn't plan on that. You shouldn't just assume that, oh, well, this is such a big deal that they'll have an extended comment period. And if you are planning to comment, you need to get those started so that you can be coordinating with others or coordinating with counsel, or if you need to coordinate with counsel in terms of developing comments, now's the time to get going on that. As I noted, the proposed rule applies to the Clean Water Act, and it applies to all of the programs under the CWA. Defining Waters of the United States has relevance for the NPDES program under Section 402, because if a discharge under an NPDES permit is to a Waters of the United States, which under this rule it almost inevitably would be, then you need to pay attention as to where those receiving waters are. It has a significant impact with respect to Section 404 permitting and the related state certifications under Section 401. A lot of the litigation that has been generated and that ultimately resulted in this rule came under the 404 permit section, because the question always arises, well, we're going to develop or alter this piece of property, and we need to know whether or not the property that we want to modify, dredge, fill, do any kind of development activity, whether there are waters of the United States, and in the usual fashion, it's usually whether there are wetlands or other ephemeral waters that need to be taken account of. And so the 404 program is where a lot of the case law is generated, and it's where, because it's the edges, that defining whether a wetland or a tributary or an adjacent water to a tributary, that's where the kind of the rubber meets the road is, and that's why a lot of the litigation has resulted in from Section 404. For those of you who do 404 work, you know that if you're going to get a 404 permit, you're going to need to get a state water quality certification from the relevant state within which the land is located. And that will, of necessity, mean that this rule will pertain to that, because the state needs to decide whether or not it has jurisdiction and whether its own water quality regulations will apply to the land or the project that you are proposing for a 404 permit. So because 404 is a big deal, 401 is of necessity a big deal as well. Spill prevention under Section 311 is also affected by this rule. And then the last thing that's not on the slide, but it actually is also within the ambit of this, is TMDL program and the Water Quality Standards program. States that need to identify impacted waters for purposes of generating and adopting a TMDL will be affected. That's under Section 303 of the CWA. Even though, and I'll note this later on, in the issuance of the rule, EPA actually did some press releases. The new director has done op-ed pieces, and they've tried to do a little bit of public outreach. They have taken the position that the rule as currently promulgated, this new rule, actually is has a smaller jurisdictional reach than the existing regulations. To anybody who deals with this day to day and who has read the rule, that is at best an optimistic statement. When I read that, I just said, yeah, right. In actual fact, this is a significantly increased jurisdictional ambit as a result of this rule, and we'll talk about that. You know, that's what the webinar is about. If the rule is adopted as it's currently proposed, it will impact the vast majority of industries that have anything to do with water, whether that's use in water in manufacturing processes, whether that is the use because you have to do discharge, whether you have stormwater on impervious surfaces. Any municipality that has to worry about doing stormwater permitting or governing those who have stormwater permit, and anybody using or owning lands where water is present is going to come within the ambit of this rule. The rule, so this slide says what I just barely said. It significantly increases EPA and the Corps' jurisdiction. You know, I've read in preparing for this and also in writing on this new rule, others have commented, and I actually agree, that the rule is so broad that you could say with some degree of confidence that under this new rule, if it's wet, it's a water of the United States. And for purposes until the comment period closes, for those of you who are advising clients, or for those of you who are in-house and working with clients, or for those of you who day-to-day work involves manufacturing or other industrial process that impacts waters, my advice would be that you view this right now as that's the easy shorthand, that's the easy soundbite to take to your respective management or your respective clients, that if you've got wet property, it's likely, and the way you should plan on is that the Corps and EPA will assert jurisdiction over that property, claiming that the wetness, wherever it comes from, makes that a water of the United States. I already noted that the comment period began when the rule was published in the Federal Register, and that it closes on July 21st, 2014. That's a 90-day comment period, and it may be extended, but again, you shouldn't plan on that. So let's talk about how we got here. There are three main United States Supreme Court decisions that kind of set the landscape or set the parameters within which this new rule was adopted. The first was United States v. Riverside Bayview Homes. For those of you who are taking notes or want to look at that, that's 474 U.S. 121. And the issue in Riverside Bayview Homes was whether or not the Clean Water Act actually had jurisdiction that extended beyond traditionally navigable waters, which it does by its own language, to waters that were adjacent to traditionally navigable waters, i.e. wetlands. So Riverside Bayview was the first Supreme Court case where the court actually said, yes, you've got CWA jurisdiction that extends not just in traditionally navigable waters, but also in waters that are adjacent or tributaries to those. And the focus of that case was whether or not wetlands fall within it. And that's kind of the genesis of the 404 Wetlands Dredge and Fill. So that's where that started. And then the Swank case, which came out in 2001, Swank stands for Solid Waste Agency of Northern Cook County, was a 5-4 decision that concerned whether or not isolated wetlands were subject to CWA jurisdiction. The facts in that case were there were isolated wetlands that did not necessarily have a hydrologic connection to any navigable water, but the Swank had jurisdiction asserted on behalf of, I think it was EPA in that case, based on the Migratory Bird Treaty Act. In other words, there were isolated wetlands where migratory birds were using those as nesting areas and feeding areas and breeding areas. And based on the MBTA jurisdiction, there was an assertion that those fell within the ambit of the Clean Water Act. And Swank, the Supreme Court, said no, that did not actually take place. That, in other words, jurisdiction did not extend to those wetlands, because the assumption was in the facts of Swank that they were in fact isolated, that there was not a direct hydrologic connection between those isolated wetlands and a navigable water, and that the only basis for jurisdiction was an extension of jurisdiction under the MBTA, and the Supreme Court says if that's what you've got, that's not enough. And this is where the significant nexus term comes from. It's in the Swank case, that there has to be a significant nexus between the wetland or the water that you are dealing with and some traditionally navigable water. Then we have Raffinose, and this is kind of the as you saw in my slides, this is the clear as mud case. Raffinose was a case that concerned whether or not isolated wetlands, again, had enough of hydrologic connection to establish a significant nexus. Remember that language from Swank. The problem with Raffinose is there was no single opinion that commanded a majority by itself. The largest opinion that had the most votes was Scalia's opinion. It got 4 votes. And that opinion says that in order for jurisdiction to obtain, there needs to be regularly flowing, and hold that term in your mind because Justice Scalia was trying to distinguish between intermittent or ephemeral waters, saying if there's regularly flowing or standing water, then that would be sufficient for Clean Water Act jurisdiction. Justice Kennedy voted with that group as a concurring vote, although he did not adopt that opinion. He wrote his own opinion, and he required a significant nexus between wetlands and traditionally navigable waters in order for Clean Water Act jurisdiction to be asserted. And it's that significant nexus language that is kind of what this rule is being directed towards. EPA has said that it intends to enforce and observe both the significant nexus language from Justice Kennedy's opinion and also the flowing standing water from Justice Scalia's opinion. But as we'll see in a minute, the new rule actually just takes a significant nexus and really expands it. It has the assumption that almost anything would be a nexus, and any nexus is significant. As these decisions have gone out, Riverside Bayview was clear back in 1985, and Swank was in 2001. In those opinions, the court has repeatedly urged EPA to, and the Corps, but it's generally EPA that kind of drives the bus on this, it has urged EPA to initiate formal rulemaking, and there's been a number of different guidance documents that were issued subsequent to the Swank decision. There was guidance in 2003, another draft guidance in 2007 and 2008, and finally the most recent, which was issued as a draft, was done in 2001. In 2001, the agency said, and I'm quoting now, that they believed it is advisable to replace existing guidance documents interpreting Swank and Raffinose in order to implement the Clean Water Act in a manner that is consistent with those opinions, reflects the best available science, and recognizes recent field implementation experience. And that was the approach they had in that 2011 guidance. That draft was never finalized, so it was a draft guidance that was put out for comment. It was never formally finalized or issued by the agencies as a formal and final guidance document. And when this rulemaking procedure was initiated in 2013, the 2011 guidance was withdrawn and the current rulemaking took over. So let's talk about what the rule actually says. And the focus of the new rule is what is a water of the United States. Are tributaries water of the United States? Are waters that are adjacent to traditionally navigable waters of the United States? Is there anything besides that? And the answer to all those questions is yes, including the other question. And we'll talk about that in just a couple of minutes. But there are other waters in addition to those. One thing that you should be aware of, particularly of those of you who either work for or represent industries or clients where you have a significant scientific need to, or a basis that you might want to check this out. The current rule is based on a report called The Connectivity of Streams and Wetlands to Downstream Waters, a review and synthesis of the scientific evidence, and it is the report that was prepared by EPA Science Advisory Board. It was issued for public comment in September of 2013. It has not been finalized. It is still out for review and peer review. Those who are doing the peer review are the government employees in the Department of Agriculture, the USGS, Tetra Tech, the environmental consulting firm, was specifically identified as an entity that did some of the peer review. And the Stroud Water Research Center and the Nature Conservancy have also been designated expressly as peer reviewers. The Scientific Advisory Board is performing the mandatory quality review of the connectivity report, and EPA is accepting public comments on that draft report. There is no back-end date for those public comments, so that might be something for you to be aware of, that the connectivity report is currently out for review. You might want to find that, see if your clients have an interest in that, because that comment period is still open, and to the extent you want to influence the scientific basis for the rule, that is the way to do that. So, as I noted before, let me see if these are the things that are per se jurisdictional, and that is just what it sounds like. Under the new rule, these are waters which have been deemed by the two agencies to be waters of the U.S. without the need for further analysis. If it fits within the definition established by the rule for these types of water bodies, then they're considered to be per se jurisdictional. The first is really easy. Traditionally navigable and interstate waters, those have always been within the scope of the CWA, although put a little star by interstate, because that will come back and it'll be an issue that we need to discuss a little further. Impoundments of those waters, in other words, if you dam or contain or use a storage facility to hold waters. I worked on a project 20 years ago, 15 years ago, sorry, where one of the ways that we managed the impacts to in this instance with salmon-bearing streams, there was so much impervious surface with this project that we collected all the stormwater that landed on this impervious surface into huge cisterns, and then that was metered out as mitigation for those the impacted streams. So that would be an example of an impoundment. So we've got traditional navigable waters and then tributaries. Tributaries to those waters. So if they're not navigable but they're tributaries to a navigable water, that would be within the ambit of the new rule. That's not really that much of a change. Those have always been viewed as within the jurisdiction. In other words, you don't have to be able to navigate it. A tributary of a navigable water would be. The difference in the rule now is that waters that are adjacent to those tributaries or within a riparian area or floodplain are within the rule. That is a change. So if you've got a floodplain, and it's not necessarily defined, is it a 100-year floodplain, is it a 10-year floodplain, is it a 50-year floodplain? If you've got a floodplain and you've got waters that fall within the floodplain, and those waters are deemed quote-unquote adjacent to tributaries within the riparian area, then they are within the jurisdiction of the new rule. And again, where the rubber meets the road and where a lot of the litigation is generated is on wetlands, which are adjacent to traditionally navigable waters. And then the interstate term that I referenced before, any interstate water is deemed a water of the United States. And that sounds intuitively obvious if there's an interstate water. Where that becomes a little bit more nuanced and difficult to see is if you have ephemeral waters, waters that are present at some time of the year and not present other times of the year. And out here in the arid West, which is where I currently practice, that's not an uncommon phenomenon. I was just down in New Mexico a couple, 3 weeks ago, and we saw the Santa Fe River, which the people in more wet areas of the country would deem a creek, or the first time I crossed the Rio Grande, there's times that becomes almost an ephemeral water. So that's a thing that you need to pay attention to, because if that is an interstate water, in other words, if it crosses state boundaries, then that would be a per se jurisdictional water of the United States. Other waters of the United States would be determined by case review, and you can see on this slide I quoted from the new rule. If, quote, alone or in combination with similarly situated waters, there's a significant nexus to traditionally navigable waters, then the Corps and EPA is asserting that those are waters of the U.S. I mean, if you just look at that language, there is a lot of ambiguity. What is in combination with? Is that easily defined? This kind of says, well, this is why we have to do it as a case by case. But you can see where there are going to be areas that are ripe for dispute, ripe for negotiation, ripe for litigation. What's a similarly situated water? Well, that's an amorphous term that the actual lines that are drawn to decide what that means will certainly be subject to negotiation and may end up being subject to litigation. And I said before, EPA claims that the proposed rule is narrower than the existing regulations. I just think that is, you know, I don't know who they're trying to fool, but they're not fooling anybody that deals with this stuff on a day-to-day basis, because this is a very broad expansion of their jurisdiction. And to not acknowledge that, I mean, they're talking that way for political purposes or to make sure that they, you know, are telling a good story, but the actual fact is that it's just absolutely not true. The term tributary is defined as, and I have it, this is the language right out of the rule, any feature with a bed, bank, or ordinary high water mark that contributes flow. Again, what's flow? How is that defined? How much flow is flow? How are you going to measure that flow? Is it intermittent flow? The answer to that question is yes. Is it ephemeral? The answer to that question is yes. And you can see that from the next bullet on this slide. The quantity doesn't matter. The frequency doesn't matter. The duration does not matter. Intermittent streams fall within the definition of what would be within the ambit of the rule. For a rule that refers to and was specifically adopted to address the question of a significant nexus, and that, as you'll recall, that term was first used in Swank, and then it was also used in Justice Kennedy's opinion in Raffinose. It's very interesting to me that the rule does not define the word nexus. So, you know, for those of us who litigate these issues or who negotiate with regulators on this issue, you know, this is a bit of a full employment act for you, because without defining nexus, there's going to be rooms for you to argue that nexus means this and nexus does not mean that. But that term is not defined. However, the rule states that waters are within the definition, and now I'm quoting, if they, quote, significantly affect the chemical, physical, or biological integrity of navigable or interstate water. The rule does define the term significant, but it defines it in a way that, again, is going to be, you know, you're almost talking about a tautological definition. Significant is defined as more than speculative or insubstantial. So, you know, you could almost say significant means significant. That term is defined. Nexus I didn't even define, but significant is basically anything above a de minimis impact. And again, I've already noted this, but by referencing interstate waters in addition to traditional navigable waters, the rule brings non-navigable waters, if they are interstate, as a basis for jurisdiction. So think about if you can identify, and I think this situation obtains more in the West than maybe in the East, but if you've got particularly ephemeral waters or intermittent waters, waters that are present above ground at some portion of the year, but they're not present above ground at all portions of the year, if those kind of waters cross state boundaries, those are waters of the U.S. by definition. And the reason that it just barely said if it's above ground, groundwater is expressly excluded from this definition. So when you are dealing with, as a lot of us do, water rights or right to use water, and you are taking that water from groundwater sources as opposed to surface water sources, groundwater is not a water of the U.S. for purposes of this rule. We're talking about surface water, wetlands, ephemeral, intermittent waters, but it's got to be above ground. It's got to be surface water. It's not groundwater. I already talked about this. What does significant nexus mean? And these are the terms I just barely read. So for those of you who get the slides, this is a quote from the rule, and I gave you the site to the rule already, so you can look that up. But it just struck me very strongly that the purpose of this rule was to address terms that had been first generated in 2001 in SWANC, and then we've been trying to figure out for now going on 8 years what is meant by Justice Kennedy's significant nexus requirement. And so for this rule to define significant but not nexus leaves a little bit to be desired in my estimation. And this, I've already talked about this. Interstate waters don't have to be navigable. Interstate waters could be non-navigable waters. They could be ephemeral waters. They could be intermittent waters. They can be there some portion of the year. They could evaporate. Those are going to be deemed waters of the U.S. Okay, so where does this leave us, and what do we care? Why do we care about this? What's the impact that's going to be? Let's talk about who would be affected by this. If you represent a developer client, you have a piece of property that has some water on it. It used to be the case that what you would do is you would engage a consultant, a wetland biologist, and they would go look and see if there's the 3 factors that you need to show for wetland jurisdiction, and they would sample the plants, and they would do analysis of the water, and then they could make a decision, and they could offer you that opinion. Another thing you could do, and it was very frequently done, and will still be done, is request a jurisdictional determination from the Corps as to whether or not the water on that property fell within the Corps' jurisdiction under 404. This rule is an attempt to avoid some of that, and the way they've attempted to avoid that is just say the answer to that question is and always will be yes, which has some intuitive appeal, but as a practical, on-the-ground, day-to-day matter, what that means is there's going to be a lot of discussion at the margins where, based on this rule, EPA and the Corps are going to assert that you've got waters of the U.S., and if you don't want to incur the regulatory cost, the delay, the time it takes to get through the 404, 401 process, you might want to argue that it's not. It's kind of like what happened when the PSD regulations in the Clean Air Act were first adopted, and the advice that was given to most people is do anything you can to stay out of Title V. Do anything you can to stay out of that PSD program. Well, the same thing obtains here. If you have a project that requires a 404 permit, that is going to be a significant overlay in terms of what you're going to need to do for regulatory approval, because you can't get permits until you get your 404 dredge and fill permit from the Corps, and you can't get a 404 permit, final 404 permit, until you get a 401 certification from the state. So you've just all of a sudden, if you fall within the ambit of this rule, you've got a very large overlay that is going to take a decent amount, depending on the project, to a really significant amount of time and resources to get through. Stormwater permits, if you represent or work for an agency that either issues stormwater permits because you work for a state environmental agency, or if you work for an agency that has stormwater permits. In the area where I live, Salt Lake City Public Utilities just had their draft permit issued. So that, you know, is going to be something that is going to be very important to understand what the scope of that is. where those receiving waters and whether those are waters of the U.S., they almost inevitably will be. And as I said, the way that this rule is structured is they are expecting the answer to the question of, does a stormwater permit discharge to water of the U.S.? The answer to that question is going to be yes, again and again and again. We talked about state water quality certifications already in connection with 404, and the 311 is the pollution prevention. So these are the issues at the margin that, in my view, are going to generate litigation. Whether or not an intermittent or ephemeral water actually is what they say it is that ephemeral water there sufficiently that it's going to become a tributary and thereby become a water of the U.S.? That is an area where the jurisdictional, I was going to say jurisdictional grab, that's a pejorative term that I don't really want to use, but the extension of jurisdiction based on intermittent and ephemeral, that's new. That's new for this rule. The rule expressly states that any waters that are adjacent to navigable. Okay, well, the Swank case was whether or not adjacency extended to isolated waters where there wasn't a hydrologic connection. The answer to that question is no. Riverside Bayview was the very first case that just said adjacency by itself means that there is jurisdiction. And Raffinose, the litigation that has been engendered from Raffinose is volumes and volumes. What are other waters? What are, the rule says that other waters that were formerly not included within either the guidance or under the case law are now included, but it doesn't define what those are. So that's almost surely going to be a topic for litigation. And I noted earlier that the definition that says that waters that are similarly situated, well, what does that mean? This is in the case-by-case review section. Jurisdiction would be waters, and I'm quoting again, or in combination with other similarly situated waters. Well, what does that mean? That's going to be an issue that needs to be decided. And again, for a rule that is issued to assess and to try to determine what constitutes a significant nexus, the fact that they have not defined nexus means that somebody's got to define it. The courts are the place where that's going to be defined. So, what are the potential costs as people who advise clients on a day-to-day basis or who work for clients on a day-to-day basis who do business in areas that this rule will affect? What do you need to be concerned about? Well, the first I've already mentioned, and that's delays that are caused by a jurisdictional determination. Let's just take an example. If you've got, say you're going to develop a new energy facility. You're going to develop a facility, and it doesn't even have, it could be a cogen facility, but the footprint of that facility, not the use of the water, just the footprint impacts waters of the U.S. Well, you have to figure out, A, are there waters of the U.S. there? And the Corps would, and EPA would want you to say yes, but you need to figure that out. B, do you impact that? Is there a way that you can put that project? Is there a way you can size the project? Is there a way you can orient the project so that you don't have an impact on waters of the U.S.? And here I'm specifically thinking about wetlands. Because if you can orient your project, if you can modify the footprint of your project such that you do not impact the wetlands and leave a sufficient buffer so that they're not going to be impacted, well, now you don't have to worry about getting that jurisdictional determination. But because this new rule expands significantly what waters would fall within the scope of that jurisdictional determination, it just makes it more likely that you're going to have to go through that. And any of you who've done the 404 process know that once you get within the 404 process, your project just got longer. It just got more expensive. You're going to have to figure out what impacts you have to those waters, what is the appropriate mitigation for those impacts, what are the appropriate mitigation ratios for those impacts, and that's going to require an assessment of what kind of wetlands they are, how significant they are within the watershed within which they fall. Are there any regional or overlay plans for improvement, recovery of those wetlands or other waters, both of the state and of the United States? Your project just got more complex. And the problem with that isn't that those issues can't be addressed. They absolutely can. The problem is that you've got a finite number of people at the core that are able to deal with those. And by expanding jurisdiction in a time of budgetary constraint, unless they put a whole bunch more staff people on there, their jobs just got a lot more voluminous. I was going to say harder. I don't know that it necessarily got harder. It's just there's going to be more volume that those people have to deal with. The other thing that's significant, and it's on this slide, is because the Clean Water Act has a citizen suit provision, and because NGOs are adept, and rightly so, I mean, that's why the citizen suit provision is there. There are some of these jurisdictional determinations that are going to be made through citizen suits. So if you have, to take the example that I just gave, and I've actually litigated this case, you have property development that is going to go on in an area where it is questionable whether or not there is a jurisdictional wetland. In my instance, the case I'm describing, my client said that they had oriented their project, moved it around, changed the footprint such that they weren't impacting wetlands, and the state and federal regulators agreed with them. So they issued a 404 and a 401. And citizen groups who did not agree with them brought suit, and we litigated that issue as to whether or not the Corps' and the state's jurisdictional determination with respect to whether or not waters of the United States were impacted. We had already won the battle with the regulatory bodies. We already had both the federal regulators and the state regulators had signed off that we were fine, but notwithstanding that fact, citizens brought under 1365 a citizen suit challenging that. You have that potential now because anytime you increase jurisdiction, notwithstanding what the Corps and EPA have said, anytime you increase jurisdiction, you can come to an agreement with the regulator as to what is going to, be affected, what permits are necessary, and a citizen group or an NGO could challenge that. And then you've got all the issues with respect to standing and whether or not they actually have interest that can support standing and what the focus of their interest is and how it's impacted and what were they in the record, was the record sufficient? Anybody who's done that kind of litigation knows that once that starts, your project just got more complex and as a result a little bit more expensive. Because this is a new rule, I've put together, I've assumed that there will be both as applied and facial challenges, particularly where, as this rule does, there is an assertion of per se jurisdiction. That's just a recipe for a facial challenge. If you just say per se this is going to be in, somebody somewhere is going to challenge that as a facial. Then you've also got the as applied challenge with respect to this particular property where we've got ephemeral water or we've got intermittent water or we've got we don't have a quote unquote significant nexus, or going back to what I talked about earlier, it's within a riparian or floodplain area. Well, which floodplain are you talking about? Are you talking about the 10-year floodplain? Are you talking about the 50-year floodplain? Are you talking about the 100-year floodplain? Those are not necessarily defined, and so that's where you're going to get an as-applied challenge. So that's the scope, and I will confess that I've been talking without looking to see if there are questions, But if there are any questions, this is the time for you to bring them up. And we can talk about those. It's because the rule has extended beyond what has been before. There are, we'd be speculating to a little bit of an extent. However, some of the terms, the core is actually, if I were going to give this presentation and I worked for EPA, what I would say is, by making clear by rule what the extent of this jurisdiction is, we're hoping to avoid disputes. We're hoping to make it easier for people to go and identify very easily and specifically what permits they need. We're trying to diffuse the potential for litigation. I don't believe that. That's not been my experience, but I could make that argument if I was a regulator. I could also make the argument that the rule does that because from the Corps' perspective and from EPA's perspective, the answer to the question is always going to be yes. If you come in and you say, do we have a water of the United States? The answer from their perspective is yes, you do. And you're going to have to work very hard and get some pretty significant technical data to show that when we've got adjacent waters to tributaries, when we've got intermittent, where we've got interstate waters that don't even have to be navigable, that those waters are not waters of the United States. As I noted before, groundwater is not, and there are some other very specific exclusions, but I think the operating and the takeaway, the operating assumption, the takeaway from this presentation should be the assumption that you come away with is if this rule is adopted as currently proposed, you should just assume that you've got waters of the U.S. So, Chris, do we have any questions that we need to address?
Yes, we do. Thanks so much for that presentation, Steve. We do have some questions. If there are any other questions, please type them in to the question or chat box. First up, will this new rule look backwards for areas that have recently had jurisdictional determinations that determined it was not jurisdictional and changed that determination to be jurisdictional?
The way I understand the question is, does it have retroactive effect? And
yes.
The answer to that question is it does not expressly say that it has retroactive effect. And so that's a really good question to raise the citizen suit. So if I had that situation, I've got a JD, and the JD has said, this is not a water of the U.S. You can go forward. You don't have to get a 404. You don't have to get a 401. You don't have to worry about a discharge permit. And I would proceed as if the new rule doesn't make any difference. And I think legally that's the right way to proceed. However, you have to understand that you have a potential, I don't know how high it is, it's probably a function of the type of project you're talking about and the water that's being impacted. You have the potential now with this new rule to have a citizen suit or a third party argue that it is not, that JD that says you do not have jurisdictional waters can now be called into question. I would argue strongly that that's not the case, that the new rule only goes forward and it's forward-looking and it does not expressly say, and if it doesn't expressly say, you're not going to have it interpreted that way, that it's retroactive, but you just need to be aware that you might have potential. I think that's a losing argument, but that argument still could be brought, and this rule only makes it more likely. I don't think they'd win, but you know, there's always that risk.
Okay. The next question. Does EPA even have the manpower to review all of these new permits that are going to be required?
The short answer to that question is no. and those of you who do this for a living, whether you are the person seeking the permit or the lawyer helping the client get the permit, already know the answer to that question. The manpower at both the Corps and EPA is already strained. And it takes a pretty long time to get through that 404 process. Some regions are better than others. Some Corps districts are better than others. But as a practical matter, it's already, the workload is already as significant or more so than the current staff can handle. And with EPA being under political attack, especially within the House, the likelihood of them adding significant amounts of staff I would view as very low. Similarly with the Corps, it's hard for me to see them adding a significant new amount of staff, and so it's going to take longer. It just is. If you've got a finite resource of staff people and you suddenly expand the jurisdiction that they have to look to, it's just going to take longer. It doesn't mean that they will never say, well, sorry, we just don't have the staff to deal with this, so go ahead. It's exactly the opposite is the case. We don't have the staff to deal with it, so it will take longer. We will spread it thinner. You might have, I had one project where the project took so long to get permitted that we went through 3 different project managers. And the problem with that, this is at the core, and the problem with that is you have to educate every single new project manager as they come in, and if you get people who are new to the field, one of those in the project I'm describing was, you not only have to educate them about the project, you have to educate them about the whole statute and how the statutory regime works. So I would view this as a problem, and you know, it's just they've got more work than they know what to do with right now, and they just added a whole bunch.
Okay, next up. What evidence is required to show there is enough buffer between a project and a water to be able to say there is no impact?
Well, that you want to get your wetland biologist out there to say, first of all, what is, if you're going to do a definition under the old regime, you're going to say, okay, is this land, because it's general land, we're talking about wetlands here, is this land have the 3 indicia that are necessary to become a wetland, the plant species and the volume of the water that's there and how deep it goes. Here, under the new rule, the assumption, as I've said ad nauseum, is going to be that the answer is yes, it does. So then you have to decide, well, how big of a buffer is necessary to protect that water? That's a case-by-case determination. Because if you come in with a plan and you say, as you would normally do, here is our wetland delineation plan. Our consultants have gone through, they've identified where the waters of the U.S. are, they've identified where they actually extend to, they've identified the wetland boundaries, and then we, for the purpose of our project, are going to say that we are going to maintain a buffer of X number of feet. Well, that's a function of what kind of wetland you have. And it's also a function of, assuming the scenario that I just barely described, whether or not mitigation that you're going to do for the wetlands that are impacted can be aggregated across the entire project, if it has to be site-specific for that particular wetland. And that's a regulatory question that you're going to have answered by the particular regulator who is dealing with your project. So I can't give an overarching answer to that question. It's going to be case by case, and it's not just case by case based on, well, this wetland deserves this amount of buffer. It's the type of wetland are going to deserve different buffers, and also your mitigation that you're offering is going to be calculated based on specific ratios, which again are wetland type of wetland specific, and whether or not you get any credit. And that can go to, is there a regional plan that allows you to say, well, I'm going to do this type of mitigation as opposed to that type of mitigation so I get a better ratio. They're all case-by-case determinations that you're going to have to negotiate with the specific regulator that's dealing with your project.
Okay. Again, if anyone has any questions, please type them into the question box. Next up, is there an estimate on when this rule and new regulations will go into effect?
Well, the comment period is right now set as 90 days from publication. So let me go back to my, I was just going to say, I'm pretty sure it's July 21, but Yeah,
So that sounds right.
the publication on the register was April 21st, so it's a 90-day comment period. That would be July 2014. That would be the earliest date. It's possible, given the breadth of this rule, that significant enough comments will be received that that comment period might need to be extended. You should not plan on that, but it's certainly possible. If you intend to comment, or if you have clients who would be interested and think they ought to comment, that's the deadline you should plan on. It may get extended. The only gloss on that has to do with the connectivity report. The connectivity report that I spoke about at the very first of the webinar was issued, let's see, what's the date of that? It was issued in September of 2013. It is still technically open for comment. It is still being reviewed by the Scientific Advisory Board, and it's technically the case that until that is completely wrapped up, that this rule wouldn't be in final. But for purposes of doing your day-to-day work, you should assume that the comment period is going to close on July 21st, that it's not going to be extended, and if it is, then hooray, you know, we're all pleasantly surprised. But that's the time you should assume. Okay.
The next question, and as of right now, last question. Does this rule extend jurisdiction to the contributing watershed? I.e., if the watershed is cut off and thereby cutting off hydrology, is that an impact to waters of the United States?
I think you could argue that both ways. The question assumes that there's no hydrologic connection. And if that is in fact the case, and you can demonstrate that through evidence that you don't have a hydrologic connection between the watershed that you're describing and the waters of the United States, then you could make the argument that that does not have an impact. As you can tell, I'm qualifying this as I'm making the answer, and the reason is because of this mushy language of similarly situated, or jurisdiction is asserted over waters. This is on a case-by-case. Remember, there are two sections. There's a per se jurisdictional, and that says in the per se jurisdictional that any tributary, and that includes waters adjacent to tributaries within the riparian area or floodplain, they are deemed to be per se jurisdictional. However, having said that, the case-by-case review under the rule states that jurisdiction would be asserted if the water, quote, in combination of other similarly situated waters, including wetlands, close quote, has a, quote, significant nexus. So based on the assumption that is in the question, that there's no hydrologic connection, and you could argue based on evidence that they are not similarly situated, that they do not have a combination with other waters similarly situated, I think the answer to that question could be no. Recognize, though, that you are fighting an uphill battle. You can win it. The people in Swank won it, but I think it just got significantly harder to win than it was a couple months ago.
Well, that looks like all the questions, Steve. Just wanted to thank you very much again for that great presentation. We will be sending the slides and recording out to everyone hopefully later today, but if not, by tomorrow. Thank you all for joining us, and hope everyone has a great Memorial Day weekend.
And again, if you need to contact me, there's contact information. That'll be on the slides. Thank you, Chris, and thank you for those of you who participated.
Great. Thank you.